A good evening to you all. Good evening. We want to welcome you this evening to our event, which is going to entirely be speaking about public health matters of our country as Uganda, but also the region, because we have a regional context of public health issues. So we want to begin by thanking you all for honoring our invitation to this conversation today. We are here to mainly have a conversation about our public health concerns as a country. We understand that the different stakeholders have taken many initiatives, played different roles and mandates to ensure that we address the very many emerging public health issues and concerns. But we still think that it is important to continue the conversation, since public health issues don't stay in the wardrobes. So today with us, we are very much honored to have our distinguished guests from various ministries, government ministries, departments and agencies, but also other stakeholders from the civil society, the media, the academia, and the rest. Important to note is that we also have another fora where we have other participants online who are listening to this conversation. So I hope along the way we don't forget them. So my name's Muhumza Abdukarim before you, working with Afya na Haki, where I coordinate partnerships and the communications. So we want to start the conversation this evening, which we anticipate to be very brief, concise, but to the point, to ensure that we have a candid conversation, because we also understand some of the guests have other evening events to attend to. On that note, we shared with you a lineup of our program for this evening. We are happy and honored to have the Director Curative Services of the Ministry of Health, Dr. Charles Soraro. Thank you for honoring this invitation. He will be giving us remarks shortly, and then after that we'll have a presentation from Nimrod Muhumza. Immediately after that presentation, we'll have a few minutes of certain categories of people responding to that presentation, which will be made by Nimrod, to have a broader perspectives into the presentation and understanding to see where we are. And as we wind up the panel, we'll be hearing from the Director of Public Health at the Ministry, Dr. Daniel Chabainze, to lead us into how do we move forward around these couple of emerging issues. So in the House, I want to recognize the distinguished guests from the Ministry of Health who are here today, led by Dr. Charles Soraro, the honorable members of Parliament in the House, and other distinguished guests from civil society, media and academia. For purposes of time, we might not hear from everyone in terms of introductions, but we request that at the point where somebody is going to speak, you kindly mention your name and institution you are coming from for this conversation. So on that note, allow me to also put this conversation before God. Yes, we might have believers and unbelievers, but generally, I want to pray to the Almighty God to lead us into this conversation and enable us digest the issues we're going to discuss, but also guide us in the way forward for this conversation. We also want to recognize the participants who are online for this conversation. When you get a chance to hear from you, we'll do that. But without wasting any more time, being an evening, I want to invite Dr. Charles Oraro to give us remarks that will lead us into the conversation for today. You're most welcome, Doctor.
Thank you. The honorable members of parliament, my colleague, the Director of Public Health, the organizers, all guests in your respective capacities, ladies and gentlemen, welcome to this dissemination of the analysis of the Public Health Act and the Public Amendment Act 2022. All of you are aware that public health law and public health policy these are fundamental tools that assist states and governments in the task of protecting people from threats to health by preventing disease, but also sustaining healthy populations, which definitely others will look at social transformation of the individual and the country as a large. So the beginning point for us as a sector is definitely that we need to look having health population. It also provides public health professionals with a legal basis on which they're able to practice. Because everything, normally sometimes I teach, I tell if you cross the other side of the law, which means everything which you do has got a medical legal what? Medical legal basis. So it defines their practice, but also defines the scope of their practice. All of us went through COVID, and I think that time you saw the legislation was even much more important during that time, and played a major role in public health systems. But all of you are aware that we had limitations of the Public Health Act, which, as you see in the report, was enacted about 87 years ago. So it had limitations. So during that time of COVID, definitely, most of the things definitely were glaringly came up. So what is key is that all levels of government, including both the private sector and even civil society organizations, have a role in protecting the public health. So all of us in this room have got what? A role. So it's not limited just to the health sector, but all of us have got a role. So the Public Act Cap 221 was enacted in 1935, and that time the main objective was ensuring protection of the public health in Uganda. However, then many sections of it therein became obsolete. And as clearly indicated in the report, others thought you probably would have repealed it completely, but I think government in its own discretion so that it wanted to amend it. So the Act does not provide for the current public health response structures and mechanisms which are covered, which covered in the National Technical Guidelines for Disease Surveillance and Response, public health emergencies, and is no longer a focus only for diseases, but also extends beyond that to include biological, chemical, radiological, and even nuclear hazards. And the response to these hazards requires a multi-sectoral approach, which should be within the public health framework. So that's what is key. The other aspect that Uganda definitely, as a country, does not work in isolation. We are signatories to the WHO International Health Regulations 205. And this definitely requires that it needs to be domesticated within the regulations to be able to prevent, protect against, control, and provide public health response to international spread without definitely disrupting trade and the movement of people. That's why you saw us when we were looking that we have to make sure that nobody who is a contact of Ebola or anybody moves out of this country, because Uganda has got an obligation to the international health regulations. We also noted that in the Act of 1935, the penalties and provisions were no longer deterrent, as they contain low monetary values. So when you have new emerging and infectious diseases like Ebola, SARS, Middle East respiratory syndrome, and COVID, it made the Act very unapplicable in the response, the mechanisms to these outbreaks. And I think that's why it was key. Lastly, in health, we talk of a one health approach, but others look at that is a multi-sectoral approach, is a partnership. So to be able to deliver public health, because as you see that most of these diseases are moving from animals to what? To humans. So you need a partnership with the Ministry of Agriculture to ensure animal health, Ministry of Mental Health, and then definitely Uganda Wildlife Authority to ensure that the health of wildlife, because all those ones, if it not managed very well, it will still end humans. And then we have to work with the law enforcement bodies we shall put in place to ensure proper implementation, because it does not make good sense for you to be able to put all this and it doesn't get implemented. What will you be able to achieve? So this evening, we're going to get this dissemination. The group has looked at this in depth, and they will be able to share with us, and we'll be able to give a response. So ladies and gentlemen, those few statements are sufficient for me to say this meeting is officially open. Thank you very much for listening.
Thank you very much, Doctor. We appreciate those words of wisdom from you. So like Doctor said, a multi-sectoral approach to public health issues where we need all hands on the deck, regardless of the sector or regardless of the disciplines in terms of the countries and other sectors. So as we plan to usher in our presenter for today, allow me briefly let you know about Afya na Haki. Afya na Haki was launched last year on 4th November, where we had the honor of the Minister of Health, Dr. Jane Ruth Acheng, together with the Director of Curative Services, to launch the institute. We are a regional institution focusing on research and capacity enhancement in the areas of health, human rights, and SRHR. And that's why we pay critical and deep attention on matters concerning health. Our institute is looking at how do we look at Afrocentric approaches in advancing health, human rights, and SRHR, appreciating the element of positive African narratives in addressing public health concerns and other issues, but also the role of the African organizations, the like of the African Union, ECOWAS, SADC, the East African Community, in advancing elements of health, our role in engaging them, but also we put a lot of emphasis on capacities of African institutions, civil societies. How do we tap into the resource we have as Africans beyond even running out to get capacities from other areas of this world? And lastly, we appreciate the role of African individuals and experts, the youths who are here in this room today, the knowledge you have, the wisdom you have. How do we share that knowledge together to ensure that we address a couple of concerns as Africans, as Uganda, concerning issues of health, human rights, and SRHR. So with that brief intro about Ahaki, we had a process of analyzing the Public Health Act 87 years down the road until this year when we had the amendment process of this act. A couple of things reflected on, a couple of issues to appreciate the current or the contemporary issues. Because one of the concerns we had around this was that this was too archaic, too ancient, not to be able to address the current trends, including the likes of the COVID-19 So to cut the story short, I want to invite Nimrod Muhumza, who is a research fellow, PhD candidate working with Afya na Haki, to take us through what are some of these findings, and then we'll be welcoming responses along the way. Thank you.
Thank you so much, Karim. Good evening, ladies and gentlemen. All protocol observed. My name is Nimrod Muhumza, and I will be your conductor for this brief session. And it is my singular honor to present to you the findings from a study that we at Afya na Haki did analyzing the Public Health Act and the Public Health Amendment Act of 2022. I would just like to start with one caveat, that the Public Health Amendment Act is still awaiting presidential assent, which raises a number of issues. And one of those issues is that, one, it's not yet law, and so all references to law in the booklet, in the published copy that is before you this evening, refer only to the Public Health Act. The second is that the Amendment Act is not yet public. So our analysis was based on the draft bill that was moved and presented by the Minister for Health, Dr. Ruth Acheng, as well as our careful and considered reading of the parliamentary record, the Hansard, to determine what was kept and what was deleted from the original bill. So the structure of the presentation will go as follows. We'll have a brief introduction, we'll have a justification for the study, the history of the legislation, where the act comes from, and then we want to look at what is happening in the region. So we considered 3 countries, select countries, and what they're doing with their public health legislation. Then we'll look at the emerging themes, we'll have recommendations and conclusion at the end. So by way of introduction, I think like Dr. Olara and Karim have mentioned, the act is archaic, or I mean it still is, because the amendment hasn't yet really triggered the, has not yet been triggered. So the act is archaic, it's 87 years old, it is anachronistic, it is not fit for dealing with today's issues, and it is colonial in the sense that it was enacted by the colonial government. So it brings with it a baggage of a democratic deficit, because it wasn't passed by our members of parliament. So that alone, I feel, should have been reason to either amend it or do away with it completely. And it also has a narrow focus, because it was enacted after the Spanish flu of 1914 to 1919. It was enacted in 1935. So it raises issues of whether it facilitates preparedness and a timeliness of response to another looming pandemic, because the experts have told us, as they did tell us, I think as late as September 2019, CNN and the WHO were warning us that we were due for a pandemic. And so when one hit, some people were not surprised. So there is another one coming. So we have to ask ourselves, how prepared are the normative frameworks on which government responses are based? The second issue is that we have new public health threats. Non-communicable diseases. Recently, I think it was the minister again who tabled the organ transplant bill because of a rising number of NCDs, kidney failure. And then, of course, SRHR, or Sexual and Reproductive Health and Rights Crisis. A report came out recently talking about how a big number of HIV/AIDS infections are now in adolescents. So these new threats are away from the typical pandemic or infectious disease threats, necessitate looking at the legislation that we have to determine whether it is fit for purpose. But it's not just new threats, because we also have new opportunities within, we have new opportunities that can help undergird or strengthen public health and public health law. right? So such as things such as information systems and information and communication technology, as well as new dispensation. Here we're looking at constitutional rights that have to be be incorporated when you're dealing with public health measures. So there is also a need to address a number of contested issues. Public health vis-a-vis individual rights, as arose during the discussion on the amendment, particularly regarding compulsory vaccination. To what extent can you subordinate individual rights to the public good? And then, of course, the right to life versus the right to livelihood. I think the president was clear on this during the COVID addresses, where he kept mentioning that it is better to be alive and hungry than dead. Then, of course, we have to ask ourselves where lockdowns, for instance, an appropriate response, because we know that lockdowns pushed 55 million Africans back into poverty and reversed years of work on poverty reduction on the continent. So all these emerging issues sort of require us to relook at our normative framework. And then, of course, the last is the African or the Ugandan context for public health measures. Again, we raise the issue of the hard lockdowns, not hard quarantines. The hard lockdowns should be assessed within the context that they are meant to apply. Next slide, please. So all that, as well as the issues that are on the slide before you, were the justification for the study that we conducted. That one, the Act dealt with the problems of its time. It mentions, for instance, smallpox, which has all but been eradicated. I read somewhere, and I think Ms. Martha will address this. The amendment came in the wake of COVID-19, although she wrote on another forum that it was not COVID that prompted the revision of the law. Although the minister did mention in the memorandum that as a result of COVID, the government did take a look at the Act to see if it was fit for purpose. Then, of course, the scope is too narrow. There are no financing obligations. There's no reference to human rights, like we mentioned about the new constitutional dispensations. There's no mention of ICT, as well as the outmoded governance structures. And so this amendment attempts to drag the law into the 21st century, and we will have to determine whether it has achieved that purpose. Next slide, please. So the main objective of the study was to undertake a review, analysis, and evaluation of the Public Health Act and the Public Health Amendment Act in light of these contemporary issues. And the sub-objectives were to review and analyze the emerging trends in public health, to evaluate whether the Public Health and Public Health Amendment Act adhere to constitutional and human rights standards, and also to develop a thematic analysis of contemporary issues in public health legislation and to make the necessary recommendations. Next slide, please. So this is obviously just a snapshot of the literature that exists. It's not everything that's been captured. But the theme, the emerging theme in the literature that we looked at was one of change, that it was necessary to change legislation to fit today's challenges. Professor Gostin, for instance, writes that old public health statutes, and this is as far back as 2001, just before SARS, old public health statutes are often outmoded in ways that directly reduce their effectiveness and conformity with modern standards, and they do not reflect contemporary scientific understanding of injury and disease or legal and constitutional norms for the protection of individual rights. In May of this year, The Lancet also wrote in an editorial that we need to reform and update the international health regulations, which were last amended in 2005 as a response to SARS. But when the Lancet looked at the international health regulations, they found that they also limited the effectiveness and timeliness of the WHO response to COVID. The International Federation of the Red Cross and Red Crescent similarly also urges the need to have adequate and sufficient legislation up to date and says that law and policy determine how we respond to public health emergencies and regulate who does what, when, and why. And so, of course, laws enable states of emergency to be declared for health crises, lockdowns and curfews, and they can expedite vaccine approvals and provide emergency financial help for people affected by the pandemic. And so the last quote there says that public health laws typically have followed public health crises. And so every crisis is an opportunity. The COVID-19 pandemic, for all the damage that it has done, I will not say that there is a silver lining, but there is an opportunity for us as a country, for us as stakeholders, to reconsider some of the structures, some of the policies, some of the laws and administrative structures that we have, and determine whether they prepare us for the crisis that we're facing today, but also for the next pandemic tomorrow. Next slide, please. So, by way of history, Uganda's Public Health Act is directly descended from Britain. And Britain first enacted the very first public health law in 1848 after a cholera outbreak. And that law gave the government power to use the military to enforce border control, which is the equivalent of today's travel bans, to forcibly enter dwellings and to ban infected beddings. And you can see the normative legacy of Britain's Public Health Act of 1848 in our law today. And so it was the country's first attempt at a proactive rather than a reactive response to public health, and it put governments at the center of public health interventions. And so as we mentioned there, that the legacy of that law is still visible in Uganda's law, even though Britain has amended its legislation dozens of times, we have failed to do that. So of course, I'm not arguing that we should amend our law because Britain has amended its law, absolutely not. But it goes to show how quickly the threats evolve and how we too should evolve by way of response. Next slide, please. And so by way of regional comparison, again, the emerging theme within the countries that we looked at was one of change. Kenya had its Public Health Act enacted in 1921, so it is older than Uganda's, and it has similar objects and scope to Uganda's law. However, Kenya has taken the task of amending its law several times, and it did that, the last amendment coming as recent as 2017. But it also further strengthened its public health legislation when it enacted the Health Act of 2017, which, among others, provides for coordination between the central government and the county governments and a number of other provisions. I invite you to look at it. Its 2010 constitution also provides for individual and public health care. So Kenya has a strong normative basis for public health mitigation measures. Unfortunately, Uganda's constitution does not have the right to health directly, so it takes some creative interpretation for someone to find that provision. Rwanda has several public health laws, such as the one on, there's a law on reproductive health technologies. So it doesn't have one piece of legislation. It has a number, it has composite pieces of legislation. And most of them were enacted after independence. pieces of public health laws. It doesn't have one composite act like Uganda or Kenya, and most of these were enacted after independence. Its laws originated from colonial era Belgium. But what Rwanda has done, I think it was in 2020 or 2021, it repealed all pre-independence legislation, including those related to public health. All legislation that were enacted before Rwanda got independence were repealed. And its constitution also has several public health related provisions. We also looked at Tanzania. Now, Tanzania is sort of the outlier in the countries that we looked at. It has a public health law that it enacted in 2009 with a very wide scope. For instance, it defines public health to mean national, community, and individual health by providing essential health services. Tanzania's law also seeks to control and contain infectious diseases as well as non-communicable diseases. It also provides for, among others, compulsory vaccination of newborns not more than, I think, 12 months. So you can see they tried to balance a number of aspects that we here are still grappling with. So the takeaway from this is that states all around the world are beefing up their normative frameworks, and that the regional trend has been to modify, amend, or strengthen public health legislation. And so on that note, I think the ministry and parliament ought to be commended for attempting to bring Uganda up to speed. This is the first attempt, and of course, you know, we hope that opportunities will present for further amendments. Yes. So diving deep into the meat of the discussion, on the scope of the law, it was our considered view that the act, the parent act, as well as the amendment, view public health primarily as a function of science, the science and epidemiology, as well as behavior control. And we felt that that was too narrow and limited to the concerns of its time, because we do know that, for instance, you cannot now, you cannot infringe on an individual's right, to enforce public health without going through the constitutional measures. The Constitution says that the right to health, well, the Constitution doesn't provide for the right to health, but all the other rights other than the right to liberty, even the right to liberty, are all derogable. But so you have to go through a number of steps before you limit people's rights, even in enforcing public health measures. Now, unlike Uganda, which did not have a single case testing the veracity of the directives, the president directives, the hard lockdowns and what have you, there were countries like South Africa where several cases were filed, fighting or challenging the government's decisions to ban the sale of alcohol, to ban the sale of tobacco, to impose lockdowns, to force people to work from home. And in all those cases, courts had to navigate this tricky terrain of saying, to what extent do you curtail individual rights in favor or in pursuit of this public function? And so we feel that both the parent act and the amendment ought to recognize this contestation, that this tension is not something that you can just do away with and simply say, well, if it's COVID or if it's Ebola, lockdown, hard lockdown. Then the other issue that we felt should be provided for is the sexual and reproductive health and rights crises. And so again, we mentioned there the teen pregnancies and HIV rates among adolescents, we feel should be treated as urgently as we treated COVID. And that would mean releasing money, taking an evidence-based approach where necessary, and altogether just treating it with the urgency that it deserves. That it's not just infectious disease, it's not just non-communicable disease that require our urgent attention. The new law, as well as the parent law, also do not address the synergies between the science and other areas, such as human rights, environmental health, like I've spoken about. Next slide, please. So, on constitution and human rights, so this is an interesting one. During our discussion, of course, we were of the view that you can't have you can't have an amendment act provide for every single thing that you feel is missing. However, we are of the view that the implementation of public health measures and the mitigation of public health threats ought to be subjected to constitutional and human rights standards. The challenge with the Public Health Act as it is today was that it was enacted at the time when there was no democracy in this country. It was imposed on us by our colonial masters. And so issues such as compulsory vaccination, issues such as, again, hard lockdowns, which, again, pitted the need to preserve life against the need to preserve livelihoods, the provision of social amenities such as food and medicines. You had people who were shot as they tried to go to hospitals to access essential medicines, the securitization of the public health response, were all, in our view, did not pass constitutional muster. So the opportunity, a huge opportunity to subject public health measures and also just generally the power of the state in imposing measures of this kind to constitutional norms, to accountability of some kind, to restraint of some kind. And that was a huge missed opportunity. It was not taken. And we hope that there will be other opportunities to look at this amendment again to provide for these, for the constitution and human rights norms. And then, of course, the redress and accountability measures. So, for the pregnant women or the teenagers that were shot because they stayed out too late during lockdown, where do they go? How do they claim compensation? You know, how do we remedy those violations of human rights? That was not addressed. So the takeaway from here is that public health and human rights are not mutually exclusive, as we've been led to believe. They go hand in hand. And so President Museveni's quip about, it's better to be alive but not hungry might need some reassessment. It might need some interrogation. And also, of course, the issue of compulsory vaccination. Now, compulsory vaccination is an interesting one because the courts have upheld it more often than they have not. Several cases in South Africa, several cases in the US, several cases in common law Europe, which would have persuasive authority here, all suggest that compulsory vaccination might possibly be constitutional. However, because of the public outcry, the democracy that we're talking about, it was deleted from the Amendment Act, which has its pros and cons. Next slide. So on governance, we looked at who was responsible for what, particularly during COVID, but COVID was only a window in our assessment of the nature and functions of the central government and local government structures in containing public health threats. And it was one of the contentious issues during the amendment process. I think the Hansard documents the Honorable Minister saying, well, under decentralization, the government cannot take charge of everything. The local governments have to have their own responsibility. And so it is not clear in the Act, the parent Act, nor is it clear in the Amendment Act who does what under the law, which is important for the quick identification and containment of outbreaks. There was a study that was done by one of the CSOs in Uganda that found that response plans at the district level, particularly by the district task forces, were ad hoc where they existed, so they didn't always exist in all the districts, and they were not adequately financed. The guidelines and the terms of reference for these district task forces also varied from district to district, and there was often issues of miscommunication between the ministry and the district task forces. So yes, there was miscoordination between local governments and the central government, as coordination was problematic because the local governments often received information and directives from the Ministry of Finance, from the Ministry for the Presidency, from OPM, and each were sending communication without the knowledge of the line, without the knowledge of the line ministry. So we feel that governance is a huge bottleneck to iron out when dealing with public health threats. And again, the Act doesn't mention anything about that, and neither does the amendment, particularly, for instance, as regards the private sector. I think you all remember the outcry that arose during COVID when hospitals, private hospitals required huge sums of money before as much as touching a COVID patient. And so Sehad and Moses Mulumba went to court and got a consent decree from the government where the Ministry of Health agreed to regulate COVID costs through the recommendation of the Uganda Medical and Dental Practitioners Council. So it is important to have these roles legally prescribed and not just for them to be contained in, for instance, the disaster preparedness and management policy. They have to be codified in the law because it is important for issues of accountability. Who do you go to when an RDC has refused to issue a permit to a pregnant woman who dies in childbirth, for instance? Okay. Next slide, please. Financing obligations. So again, neither the Public Health Act nor the amendment deal with the responsibility of financing public health interventions. At the central government has a remedy for this, pass a supplementary budget. The local governments do not have a similar escape route. And again, the study that was done by the CSO, I think it was ACOD, found that most districts did not have response plans or budgets in place to fund COVID response measures. Only those that had experience with the Marburg virus and Ebola had COVID response plans in place. So the absence of a clear strategy for resource mobilization affected the provision of things as basic as hand washing equipment, PPEs, and the establishment of isolation and quarantine centers. The presence of direct funding to local governments is essential. It is essential to address emergencies like the breakouts of pandemics and natural disasters in local government. I said there that we said that we never seem to have money for public health crises, with the appreciation of the fact that we're a small economy. Of course, money is not always going to be around, but it is extremely crucial. It is extremely crucial to move from an ad hoc system of financing of public health interventions to one that is systematic, to knowing where the money is going to come from, who is going to account for it. The Auditor General's report recently was just released. It also makes for some uncomfortable reading, as I'm sure you know. So the best value for money depends on having streamlined public health governance systems. And without these systems, finances will continue being misused. And this can be done either in the Public Health Act or the amendment, or by amending necessary legislation like the Public Finance Management Act. Next slide, please. So ICT and information systems are a crucial factor in regulating public health crises because they are relevant for the dissemination of information, for the storage and retrieval of data, modeling and predicting outbreaks such as COVID, Ebola, and what have you. And they were instrumental. The use of ICT systems was instrumental in the performance of district task forces to coordinate activities amongst themselves because they relied on WhatsApp, Zoom, and emails to coordinate their response. So there is a need to intensify e-governance, particularly at the local level. A number of private organizations developed contact tracing apps, to help the ministry trace people who had been in contact with those suspected of having COVID, for instance. But these were not widely used. In the event that they were widely used, of course, they would raise issues of the right to privacy and the right, of course, to confidentiality, the right to privacy of the person, privacy of the home. So it is important that we recognize that ICT can be a double-edged sword. It has its negatives, it has its positives. And again, the Amendment Act was a huge opportunity to sort of put the government on the right side of the use of ICT for public health interventions. It is also important to recognize that where misused, they can widen the rural-urban or have and have not divide. Because the issuance, for instance, of COVID certificates is being done online. We know internet penetration in the country is not that wide. So we need to implement the provisions where ICT has been relied on. It has to comply with necessary legislation, such as, for instance, the Data Protection and Privacy Act. Next slide, please. So, the recommendations. I'm aware I've gone up over time by about 10 minutes, but I'm done. So, we did recommend a repeal and replace of the Public Health Act originally, but we later got wind that it was passed and it is awaiting presidential assent. So, in light of that, because the amendment hasn't been assented to, it could still be returned to Parliament, that the scope and definition of public health be broadened. The amendment does not define public health, at least the amendment that we saw, and it was also not covered in the Hansard. So it should include the things that we talked about, such as the SRHR issues. The implementation must be guided by Uganda's human rights principles and obligations, and the law must clearly spell out the interdependence between the right to health and socioeconomic rights, the right to life vis-a-vis the right to livelihood. There must be community involvement and participation at implementation and management stage of the law, and the mandates of key stakeholders, the Ministry of Health, RDCs, district chairpersons, as well as the private sector, must be spelled out, including us, CSO organizations. Next slide, please. In conclusion, pretty straightforward. The Act was out of date, and in our view, it was not fit for purpose. The amendment is a welcome initiative to improve access to universal health care and maintain a healthy population. And the process should not just stop at amending the law. Stakeholders must be empowered, capacitated, and well-resourced to undertake the necessary tasks under the legislation. Was it a missed opportunity? I think we'll let you be the judge, the amendment, but we feel that it was, because this was Uganda's chance to overhaul the entire legal and administrative framework surrounding its very old public health legislation, and that was not taken. Next slide. So thank you very much. That's been our presentation.
Thank you very much, Nimrod. Let's give him another round of applause. A lot to digest, but the beauty is that some of us had already interacted with this piece of information. So I don't want to waste any minute. I'm looking at the clock. I want to head into the next immediate session. I want to invite Nsedoko Ibrahim to lead us in the next conversation.
Thank you so much, the presenter and the initial speaker, Dr. Raro. I think from the presentation, we see that the move to amend our public health legislation is not the only case for Uganda, but there are a number of initiatives across the world that have been initiated to ensure that we can have reform of our public health legislations. For instance, I've been trying to read about the international health regulations. There are a number of moves way back in May, in September, where some countries are pushing for amendments of the international health regulations, which inform part of the objectives why Uganda seeks to amend or has presented an amendment of our public health legislation. So the need to prevent and protect public health is not only an issue for Uganda, but it's a global and regional move. So we are in the right direction, and we commend the Minister of Health, we commend the Parliamentary Health Committee and the rest of the members of Parliament, as well as civil society, for all the contributions that led to the passing and conceptualization of the Public Health Amendment Bill. So before us, we have a panel of distinguished people. They are experts in their different fields. We have a member of parliament, Ahmed Stas, Dr. George Pokadidi. Kindly join me in inviting Dr. George to join the panel. Dr. George is a medical doctor. He's a public health specialist, and he's a recipient of an award in 2005 for his distinguished support on HIV strategies and interventions in West Nile region. He was awarded a prestigious Lukia Award. Dr. Matthew Lukia was very instrumental in the fight of Ebola in northern Uganda. So he's in the capacity of the acting chairperson of the Parliamentary Health Committee. So he's a very important resource for this conversation. We also have Miss Martha Isabella Chan. Martha is a lawyer, a member of Uganda Law Society and East African Law Society, and she's a legal advisor, National Action Plan for Health Security at the Ministry of Health, and she was a brain behind the drafting of the Public Health Amendment Bill together with the team at the Ministry of Health. Join me in welcoming Martha. Our last panelist is Ms. Nachibuka Nuru Musisi. Ms. Nachibuka Nuru Musisi is a Deputy Executive Director for Programs at the Center for Health, Human Rights and Development. She's a lawyer. She has led advocacy campaigns at both national level and grassroots level, and she has been instrumental in creating change in the area of maternal health, in the area of sexual health and rights, and now she's going to share insights on public health. So we have a well-balanced panel, which I think is going to give us insights in the presentation, but also general issues of public health legislations. I've been advised to join them. So I think we'll start with Dr. George. Dr. George, do you think that our legislation was a quick legislative fix, or you think it was timely for us to have a public health legislation in Uganda amended?
Thank you, the moderator, ladies and gentlemen. A pleasure to be part of this conversation when we are responding to a critical analysis of the context as well as the content of the Public Health Act and the Public Health Amendments Bill for this matter, because it's not yet been ascended to by the President. I want to start by thanking Afya Nahaki for the initiative you took to dive deeper into the laws, the two pieces of legislation. And I've just been thinking loudly that I wish your inputs came at the time when we were getting public views. That would have given us an opportunity for some of your very valuable recommendations to be captured in the laws we are reflecting on. I will have two sets of responses to the question asked on whether this has been a quick fix or a fundamental change to our public health legislation. Starting with an overview, public health is a key element of human undertakings. We know we now have about 8 billion population, and 45 million of this is in our country. So putting the health and well-being of humanity in our public health legislative agenda is very, very key. Very, very key. We do this because humanity is threatened by diseases. Now we've a double burden of diseases, if not triple. We're dealing with infectious diseases, we're dealing with non-infectious diseases, and we're also dealing with emerging diseases. All these require a well thought out response mechanism from various principles that have to guide them. The first principle, of course, is the principle of using a human rights approach to legislation. And we actually had a balance between should we make this within the public health law or act, or this is something that should be captured elsewhere. After a lengthy debate, we decided as the health committee that within the Constitution there is a Bill of Rights. And we know within our Constitution that health and healthcare issues have not been adequately addressed, and therefore we referred the matter of health as a right to a constitutional review process, and that is work in progress. 2 is health as a sectoral issue. We also feel that within our public health legislation that should have come out very, very clearly. And we're torn apart between having the entire bill, actually the old or parent act, set aside and a new act put in place. But then we're guided also that if a certain percentage of articles or provisions within the law are amended, it will have some consequences. So we had to trade off to keep the old law without totally throwing it out and replacing it with a new one. Actually, at one point we said we need a national health law. But then we said, given the time constraints, we may not have to deliver that as a matter of urgency. Let's amend the existing law and at an appropriate time think about looking at a health law. That also raises the issue of sexual reproductive health as being part of it. This Public Health Act. We had actually 3 recommendations, one of which is NCDs and the other sexual and reproductive health. But then we had to consider NCDs as part of this law, and sexual reproductive health would be considered in the Broader Health Act. We know it's a gap for now, but it will be considered in the Broad Health Act. From the framework we initially agreed to adopt, we said, 1, we need to really look at the burden of disease broadly. That includes infectious, non-infectious, sexual reproductive health issues, and any other emerging public health threats. But we had to tone it down, mainly to infectious diseases as well as NCDs. 2 was in the scope of the response. We did emphasize the need to balance between health promotion, disease prevention, and treatment and care or curative services. But again, because of various considerations, we had to tone down the scope from broadening it up. In the governance aspect, we did recognize that a lot of changes have happened in the governance framework of this country. The national level upstream business, the role of the regional entities, the role of local governments, lower local governments, including the parishes that have become now very influential administrative units, and the VHTs up to the community, the household and family level. But then, we said if we pack everything within the law and given the principles that have to guide the law, we may overload it. And we thought some of these issues that can be handled administratively. And so the minister got given powers to come up with regulations. And we recommended the regulations on governance and a number of other areas and guidelines within the law. Planning, both short-term, medium-term, long-term planning, was something we considered, as well as sustainable financing. But then we also got guided that there is, as we speak now, a national health financing framework, which goes into details to address matters related to financing of public health interventions at the national, regional, and subnational levels. It went beyond financing. We looked into actually then a health systems approach to public health response, looking at the various pillars of governance, planning, financing, human resource. Under ICT, we didn't look at just ICT, but appropriate technologies that need to support public health response, including quality of products and services offered, the cost of them, but in the interest of balancing various considerations, we had to come with the piece of legislation that we presented to Parliament, was passed by Parliament, and has been sent to the President. And for your information, the President sent back the law with just some minor queries that were responded to by the Health Committee and the House, and sent back to the President. And we are optimistic that sooner than later, the President will be able to assent to that law. But moving forward, a law is not cast out of stone. It's an organic piece of instrument. Many of the issues and concerns that you raised and the recommendations that you have given, I think at an appropriate time will be taken into consideration in amending it. And my final call, really thanks to you, is the comparative legislation aspect that you brought up of looking at our piece of legislation, comparing it with other pieces of legislation to see to it that we are synced within the framework of the Sustainable Development Goals, the International Health Regulations Framework, and CDC Africa is doing some work related to how we have to come up with comparative legislation within the context of CDC Africa and the auspice of AU, the African Union. And as we move together as the East African community with a population of about 300 million, and we each of the 7 member states in one way or another having its own version of public health legislation, it's had high time we reviewed our legislation and synced and harmonized and aligned for us to be able to have a fairly standardized response as the East African community. So this is work in progress. I thank you.
Lastly, before I get, we got the other speaker. Do you feel that the uncertainty in the institutional mandates is well covered in the legislation, in the bill which was sent back by the President?
True, there are gray areas and some areas that require to be fixed. But I strongly believe some of the matters are matters that can be addressed administratively, because we have sufficient administrative frameworks that should be able to handle some of those issues. You know, when we overload a law with the content, and then implementing it becomes a little bit of a challenge. Let's appreciate that the law provides us the skeleton, and the law has to be supported by appropriate policies, and the policies have to be supported by a strategic framework, and the strategic framework has to have programs. The flesh of most of these comes in the strategy and in the programs. Thank you.
Thank you so much, Doctor. Martha, we have quite a number of looming infections. Some time back, monkeypox was an issue. Now, currently, we have rising cases of COVID in China. And remember, China was a place where COVID, in quotes, COVID started. Don't quote me, but that's what we read. But also we have a high burden of NCDs. We have increasing infections of HIV among the adolescents. Do you feel, what informed the choice of the approach in terms of the amendment versus having, repealing the entire Public Health Amendment Act, a Public Health Act, and then have an entirely new legislation? What informed the choice of approach for the ministry?
Thank you very much. I would like to appreciate, I can't pronounce the word very, Afianaki, for this forum and this discussion. I'm very, very much impressed, and I would like to retaliate what the earlier speaker said, how I wish we had had this kind of attention at the beginning of this reform process. I must say, you may not know, but this process began in 2012, and I was brought on board to expedite it. And I must say, unlike other parts of the country and the world, I benefited so much from the outbreak of COVID-19 because of the outbreak of COVID-19, everyone got interest. Everyone learned so much about public health. Everyone learned so much about disease outbreaks, lockdown, and all these measures, mask wearing and all that. Before then, I didn't have that much attention from stakeholders. Actually, I must say, by the time we went to Parliament, and the response Parliament got from stakeholders was so much stronger than what we got as a ministry. We actually engaged some of the CSOs. I think there was an umbrella organization called HEPS. We engaged SEHAD. We had participation in those meetings. But I must say, with the outbreak of COVID-19, we got a lot more attention to the reform process. And then before I answer your question, there's a question to the earlier speaker about the governance part. And I feel there's a gap in the presentation that was made earlier on. We need to appreciate that actually, I don't believe there's a problem with governance. Because even as I was doing the work on the reform process, I realized there's not much knowledge on how the decentralization actually happened. What is done at the government level, central government and local government level. And that comes out very clearly in the Constitution. I think it's Article 187, which talks about the mandate of central government and the mandate of local government. Then the 6th schedule to the Constitution also says that central government has a role to come up with policy and also to respond to the disasters and pandemics and epidemics, which means if you're going to have a malaria outbreak at a particular threshold, it's a mandate of local government. But if you're going to have a pandemic threat kind of disease like Ebola or COVID-19 or CCHF, any of those very hemorrhagic fevers, that's now the mandate of government. So it is for us to really, when you're looking at laws, to look at all the other spectrum of laws. If it is ICT, look at those laws under NITAU, the Ministry of ICT. If it is governance, local government, look at the local government structure, because it is very, very detailed on who does what, how we handle disease outbreaks, how we handle garbage, sanitation, and all these. So I think that is lacking, and I don't think there's actually a gap. Because if we appreciate how that works, because now like in the Local Government Act, we talk about the minister, that is central government, then the DHO will represent what is done at the district. The DHO reports to a COW or RDC and all that. That has to be understood. Then the village health teams, the regional, the health center 2, 3, 4, all of those are reporting to the DHO. Okay? So it is even us at the ministry to appreciate where we stop. We only come in to work with local government when it is actually a pandemic kind of disease or an epidemic. That's when we come in to work with local government. Actually, most of the outbreaks are supposed to be controlled at the district level. So it is really in the Constitution. I don't think there's really a gap as such. I'd like to understand where the gap comes in. I need to know that where that comes in really. Where we had the challenge, I think it's the same challenge we faced with the Committee of Health was how do we bring in private sector? That remains a question mark. How do we bring in private sector? Because we realized at the peak of the outbreak of COVID-19, actually there's a role to be played by private sector. How do you bring in the CSOs? That is also a question mark that still remains. Now, to answer my question, in terms of what you're proposing, why didn't we overhaul the old law and replace it? In drafting, we call that a repeal and replacement. And it has been done before. I think if for lawyers who are here, for the Companies Act, Cap 110 was repealed wholly and replaced with the current law of Act of 2012. And we decided not to do that because we realized that we would lose out a lot of valuable provisions. And indeed, unlike what the earlier presenter said, that the Act was archaic, when we are drafting laws or amending laws, we don't amend laws because they are archaic. We don't. We have other reasons why we amend the laws. For example, for this particular Act, when the process began, there were new structures in government. We didn't have, for example, the DG, the Director General of Health Services in the Public Health Act. We had the Chief Medical Officer. That had to be reflected, had to be amended. We didn't have decentralization introduced in the current Public Health Act, hence we had to amend. Then as signatories to the International Health Regulations 2005, we have particular obligations to domesticate those regulations into the Public Health Act, and that's why we actually had to amend. So we decided not to repeal and replace because we thought we were going to lose valuable provisions in the Public Health Act. And indeed, if you recall, and if you had access to the COVID rules, which I was part of the drafting process and the review process of all of them, we didn't have very new provisions in there. We actually used the Public Health Act as it is. The advantage of a law that was passed under the Spanish flu is that we had many provisions which are applicable to the response to COVID-19. Things like wearing of masks, quarantine, isolation, all these were in the Public Health Act. We didn't come up with anything new. Actually, the only limitation we had in the Public Health Act were the low monetary values. You could only arrest somebody. And during the outbreak of COVID-19, you could not just arrest somebody and take them to Rizia. That would actually worsen the situation of the spread of the disease. So we had a problem of, we could not fine anyone because the Public Health Act had the highest fine in the Public Health Act right now is 2,000 Ugandan shillings. So we thought that it's better for us to amend. And of course, even the Ministry of Health officials have complained because in Uganda and world over, reading an amendment is extremely hard. They wanted us to merge the amendment with whatever was retained and make it easy for people to read. However, I'm just a consultant, and Attorney General advised that we simply just amend it and not repeal and replace it. Thank you. I hope I've answered the question.
Thank you. Before we take leave of that very important issues you are raising, do you feel that our current, I think it is a bill now since it is not yet law, do you feel that it fits the constitutional dictates, especially on rights, or do you feel there are some gaps that if there is an opportunity presented, they can be rectified or inserted in the law? Do you feel, are you happy with the legislation?
That's a very difficult question because I worked on the process, so it's not, I can't say I'm happy with it.
In terms of the confines, the law being aligned to the constitutional norms that we have, the Bill of Rights and the rest of the issues that many stakeholders were raising in the course of the consultations, do you feel these have been fully addressed in the current legislation as passed by Parliament?
Thank you for that question. The thing is, as lawyers, I prefer that we read laws as one. That's why they're called chapters. So it is hard for me to say that the Public Health Act is lacking in terms of rights, yet it is in the Constitution. You read it together. It is hard for me to say that probably there's a problem with ICT, yet we have laws on ICT. Read the laws together. So that's why we call them chapters. It's all one book. Okay? So I'm a bit uncomfortable about saying that. And then also, I must commend the Committee of Health. I've said this to the chair, and probably I've never said it to him in person, but they did a very thorough job because I know the earlier presenter said that he didn't have the benefit of reading the current bill as it went to the president. But indeed, there are provisions there that would actually help the argument about sexual and reproductive health rights. I think it is Honorable here who came up with that provision. Very detailed, talks about access to health services, protection of women rights, welfare, and all these rights of the disabled, all this is in there. It's a big provision. Of course, as working for government, I would wonder how government is going to ensure this happens. But on the other side, I'm also an individual and a citizen of the country. I feel it's a very good provision, and I'm very happy to read it out to you, if we have time, or to share it with the former presenter, because it's a very good provision, because it reads, if I may.
Kindly go ahead.
It is clause 76, and I think it was actually one of his proposals. Government's obligations in public health services. Government shall take all practical measures to ensure the provision of basic medical services to the population. Okay? I must say there's a bit of this in the Constitution, but here it is really brought out. Government shall ensure that all Ugandans have access to health services. Government shall provide health facilities and opportunities necessary to enhance welfare of women, to enable them realize their full potential and advancement. Government shall ensure that no child is deprived of medical treatment for any reason. Government shall take appropriate measures to ensure that persons with disabilities realize their full mental and physical potential. Now, this is among other provisions. There's also provisions on NCD's health promotion. So I think these are good provisions, and most of these good provisions actually came out at the committee stage. Okay? So I think if we get access to some of these the particular version I'm reading right now, you can even come up with rules to make it even more applicable and suitable for the citizen of this country. Thank you.
So there is room for catering for areas which we feel are not catered for in the regulations.
There is actually, there's always an argument that you can't bring what is not in the Act, but the way the Parliament did it is that it made some general provisions that make room for it to actually come up with others. Because even if you look at the provision on NCDs, it's so general. You can bring in nearly anything if you want to. Okay? Yeah.
So that is a new legislative and creative approach. Thank you so much, Martha. Noor, Martha commended SEHAD and other civil society organizations for their contributions during the consultation or consultative process. So do you feel that the views of civil society were captured in the bill which was passed by Parliament?
Thank you, and thank you everyone. First, allow me to commend the government for thinking about a public health legislation amendment. I think it came in handy, and specifically allow me to commend the Parliamentary Committee on Health. I think the time we were inputting into the bill, we almost had a sitting of the committee in a hotel to look at the bill from the first letter to the last. And at one moment I felt like, wow, this is really interesting. We had Honorable Ayume and almost the whole committee sit to discuss that. I can say that I have not looked at the yet to be passed bill, but I'm aware that around 18th October, the president sent it back. And some of the things that the president really sent back to were things that we're raising, including discussions on vaccination vis-a-vis immunization, which I think the president looked at and sent back. And then I think there was some bit of providing mandate to the Director General, somewhere around, I think, clause 37 or 27, and clearly indicating that they should use the word assigned rather than appointed, because the Director General had no mandate to appoint staff, something like that. But I think for me the key thing is that even what the president sent back are things that we had looked at. And I cannot say that I am happy with what is provided, because what we know is just read in the papers. We have not received a final of this bill, but what we read is quite interesting, that a number of the recommendations that we provided were actually taken into consideration as the bill was being revised. So I think I can only say that. I hope that in the final things that we raised, including discussions on, for example, where there's an outbreak, information will be provided in public spaces. We had questions about the disabled, because a public space, if I am blind and the information is just pinned on the wall, I will not read that information. I felt like there was that bit of information that needed to come out. I love the fact that we are speaking about a health act that Honorable is already looking at, and also the fact that the drafter of the bill is already indicating that some of the things are in there. So for me, it's room that actually, if we really pushed for a health act, perhaps we'll have conversations on a number of these things that are really not catered for. I'm, for example, very aware that we have the National Environment Act, but we have a lot of noise pollution at the moment, and perhaps the Public Health Act would have been a one-stop center for all public health concerns that we have in the country. And again, I have not seen it, but what I have heard being presented is the discussion that some of the things that we saw the minister do during COVID were actually being picked out of the Public Health Act, not the bill. And the act does not give her that mandate again. One thing that I know, for example, is the fact that court has decided that the minister provides costs for accessing medicines. But pricing. But I have heard that when you read the Hansard, that mandate is not there in the Hansard. An indication that, again, we shall go back to conversations of how do we even implement our own rulings that we have in court. So, Mr. Nsereko, I think for me, until I see the final assented to document, I cannot say that I'm happy or not, but what I read from the papers is enough to give me that satisfaction that what we input into the bill was actually catered for. Thank you.
Thank you so much. In Dr. Aro's opening remarks, he made a statement. He said everyone has a role to play in implementing public health issues or interventions. Do you see civil society playing a role in implementing the public health amendment bill or act, God willing, if the president assents to that law soon?
Absolutely, thank you so much. I could clearly indicate that at one moment I posed questions to people to just imagine Uganda without civil society. And I'm sure we all have different responses, but the role played by civil society and private actors in the health sector cannot be undermined. So one thing that I have seen civil society do is to pick the legislations as passed by Parliament, assented to by the President, and go back to the most vulnerable that should be benefiting and educate them and show them the roles they have in there. And I think for me that bit of public health is quite important because Parliament does its job. They pass the legislations. But questions of who then goes to pick these legislations, to interpret them for the communities that should be benefiting, I think is a missed opportunity, and this is the gap that civil society kind of comes into bridge. But also the other gap is to hold the government accountable because we pass these laws with an assumption that we'll have them implemented. And where they're not implemented, I think that's the other bit that civil society really does. And I feel that there's quite a big role for us to play. Beyond having them on paper, it's really implementing what the legislations that have been passed are for people to understand them and to know them. People have asked why we did not present this particular paper at the time of the public inputs. And I'm wondering if we missed the opportunity as a Haki then, how about someone in Nakaseke? Did they even know that they have mandate or an opportunity to input into such a bill? So sometimes the information might be there but does not perhaps scale down to so many people. And I think this is the gap that civil society plays, because then we pick up, go back to the communities, have their views, put them together and present them before Parliament. So the role is really there. And we think that will play much the moment we have the bill assented to by the President. Thank you.
In case the President gives you an opportunity to make just one amendment, insert an amendment, is there anything you feel should be inserted
I would pick this report and present it to Parliament to include most of the recommendations here into that, because by the time they're being presented, the gaps that have been seen. Thank you.
Thank you so much. Doctor, we really appreciate your contribution. You have rightly said that the President sent back the bill with a few comments, and we thank the team that initiated this and deliberated on it in Parliament and the different committees. Do you feel there is a window? Is there a window for inserting any new amendments, or it is only restricted to what the President commented on?
Yeah, thank you. One of the areas that we discussed at length and we thought needed to find a place in that law is public, private, and community partnership for public health action. Because whereas in the past, it's been the role of the government to take up public health response efforts, today and in the future, the civil society, the private sector, and community groups will play an increasing role in public health action. So having that put in the law would strengthen the engagement of the civil society and the private sector in public health action, not only in terms of financing, but one in policy conversations. The inputs of the civil society have been very, very instrumental in shaping the public health bill that we passed. In planning and programming, a lot of actions are done by the civil society in both development and humanitarian contexts. We need to recognize, we need to appreciate the role of the private sector, as well as in financing. If you look at the health sector financing landscape, the private sector, and this both for-profit and not-for-profit, is making significant contributions in mobilizing and leveraging resources, domestic resources, offshore resources, to supplement and complement the efforts of government. So that's one area that I feel is important to emphasize in the law. Thank you.
Is there any other parting shot you'd like to share with us before we part?
Yeah, thank you. I just want to once again thank Hakia, Afya na Haki, for the critical analysis or review of the Public Health Act. I call upon many other civil society entities, academia, and the researcher to emulate the good work done by this entity. I think in the pipeline, what is coming next to us as the Health Committee of Parliament is likely to be the National Health Insurance Scheme. We look forward to a similar in-depth analysis, comparative legislative experiences from like-minded countries to see to it that the National Health Insurance Scheme that will formulate for this country will be a good one for the citizens of Uganda. Thank you.
Thank you, Martha. I'm really very happy that you have led and continued to lead this conversation on the public health legislation. But in the presentation of Nimrod, we saw a comparison. He brought out what other counterparts, our counterparts in the region have done in terms of public health. If you measure our legislation with those laws, do you feel that some lessons we need to pick, or Uganda is going to be we are going to be the pioneers of a very good, I don't know if good is an abstract, but do you feel that people are going to learn from us, or there are some lessons we can pick from our counterparts if we get an opportunity of another amendment?
Thank you very much for that question. I think learning from his presentation, and indeed there's a lot to learn from there. I think we can copy from Kenya. there may be some benefit to separate the public health legislation and the health legislation. Because I have that worry that many times we mix the two, yet when we have public health emergencies happening, we respond in a different way. Because most times if it is health, you go straight to that. It will be about an individual, yet for public health, it's actually about a group. If one is sick, the rest of the group is sick. So there are some issues that were raised, recommendations that you may think should be put into the Public Health Act, yet indeed it would be very smart to have a health law. Okay? And good enough, I know Honorable here, Doctor, has talked about it before. Actually, the first meeting we had, the retreat we had with the committee, that's the first question he asked me. I think you remember, can't we have a health act? Can't we change the name? Okay? I think it would be very beneficial in terms of drafting and legislation reforms to have two separate laws. Because even the approach would be different. I can give an example. Internationally right now, we are amending the international health regulations, and Uganda is fully participating. Actually, invited my colleague from the ministry, Dr. Anne, behind there. She's a national HR focal person. And we are amending that law. And it is being amended, especially because of the COVID-19 outbreak. And on the sidelines, we're also coming up with a pandemic treaty. I don't know whether you've heard about it. Now, the pandemic treaty is now like a bigger whole picture about every other thing that you can't cover in the international health regulations. That is now the scenario of the public health law and a health law. If you could follow what is happening right now, because the meetings are going on, and I'm very sure many CSOs should be interested. We've invited some, but the response has not been the best. The pandemic treaty negotiations are going on. There's one happening next week on Monday. We shall be represented in here by our director who has just worked will be representing us. But there are positions in there that actually can be covered, matters to do with health. So I think Kenya made a good move, and I hope one day Uganda can do the same, to separate the two. Because there are matters you'd want to put under public health, and they don't really come out well there. They would come out so well under an individual and independent health law. Actually, some of the things we try to put in here, in the amendment, which were introduced by the committee, they were very good, but I think they would hold more ground and hold more water in an individual health law. Thank you very much.
Any parting shot?
Sorry?
Anything you'd like to share before we...
I'm really happy about being able to speak here and to be invited for this meeting. I'm very much impressed that there's so much interest in the public health laws. When I was beginning this assignment, I failed, I must say. I searched around the legal fraternity who can join us in these discussions on public health law. Many people are focusing so much on health, medicine, clinic, all these issues. The issues to do with community, disease outbreaks, NCDs, not so much interest. So I'm happy that this is happening. I'm actually very much interested in these discussions because now, if the law is passed by the president, then we're going to come up with regulations. I'll be very happy if the participants here participate in the discussions, because now regulations is now the hands-on, and there we need real information from everyone. So my parting words to the participants and to the organizers, I hope you can participate in the drafting of the regulations. We shall be drafting regulations on the notifiable diseases, on NCDs, on malaria outbreaks, on public health laws at the points of entry. Thank you very much.
A round of applause for the panel and for the moderator. Back to you, Mr. Muhomoza.
Thank you very much, everyone. Again, we appreciate your contributions to these conversations, our dear panelists, and the moderator for the panel. We thank you for leading us in the conversation. Yes, at the time, we're not doing well with time. We want to give an opportunity to 3 individuals who would wish to make any further contribution to this conversation, if there is any, before we go to the last bit of this conversation today. Any submissions, additions to the panelists? 1 or 2, 3. We are all comfortable with the conversation? right. So we want to thank you once again for accepting to join us to have a conversation on our public health issues as a country, but also borrowing from our neighbors on how they are managing and a bit of lessons we've really learned from them. As we get into closure, we were supposed to have Dr. Daniel Chabainze to close for us, but I want also to have the honor to request Dr. Dina Nachiganda to help us close this conversation officially. Please. Closing. So because we have people online, I do want to
Thank you very much, Mr. Mhomza, the Director, Clinical Services, the members of Parliament here, colleagues, senior colleagues from Ministry of Health, and all of us in the meeting. Good evening. My role is quite easy, just to close the meeting, but also to say thank you very much, Sehad, for gathering us in this meeting. I think for me it's been lots of learning, and during the panel discussion and the presentations I was wondering, so what are all these things about? There are lots of things, laws, acts, amendments, but I think it's common to all of us, at least on the table where I was seated. And I'm glad that I was seated with Dr. Ann, who is even a senior in these things, as Ms. Achan had mentioned. So I think it's still work in progress like we've had, and there is still lots of things that we can do to input into whatever exists. And I think with the help of the different stakeholders, again, it's something we can have conclusively before the President actually signs off the act. So thank you very much all for attending. I want to say it's been very exciting, and we can hope that we will have more engagements even after this meeting. I think there is still room for us to understand a few new things. So thank you, and I want to declare this meeting closed.